chasing the police every single day.
Got a cell phone? Well, that's enough to make you a target of police surveillance in the US. This snooping is being done across the country using a secretive device called a Stingray. Here's how it works. Your phone has to connect to a cell tower in order to send or receive phone calls, messages, and data. When the Stingray is turned on, it simulates this tower and forces your phone to register with it. Stingray can then collect your phone number, location, the list of phone calls you've been making, and all sorts of other data. It doesn't just gather information from individual suspects, but anyone who happens to be in the area of an investigation. And all of this without a search warrant. So remember, even if you are just passing by, the police might be listening in.
Florida Senate, 2019 SB 210. By Senator Brandes. 24-00393A192019210210__. 1A bill to be entitled 2. An act relating to searches of cellular phones and 3 other electronic devices, amending S 934.01, FS. 4. Revising and providing legislative findings, amending 5 S 934.02, FS, redefining the term oral. 6. Communication, defining the terms microphone-enabled. 7. Household device and portable electronic. 8. Communication device, amending S 934.21, FS. 9. Revising the exceptions to conduct that constitutes 10. Unlawful access to stored communications, conforming a 11. Provision to changes made by the Act, amending S. 12-934.42, FS, defining the terms mobile tracking. 13. Device, real-time location tracking, and 14. Historical location data, authorizing an 15. Investigative or law enforcement officer to apply to a 16. Judge of competent jurisdiction for a warrant, rather. 17. Then an order, authorizing real-time location tracking. 18. Or acquisition of historical location data, requiring. 19. An application for a warrant to include a statement of 20. A reasonable period of time that the mobile tracking 21. Device may be used or the location data may be 22. Obtained in real time, not to exceed a specified 23. Limit, authorizing a court to grant extensions that do 24. Not individually exceed a specified limit, for good 25. Cause, deleting a provision requiring a certification 26. To be included in the application, providing that the 27. Court, if it finds probable cause and finds the 28. Required statements in the application, must grant a 29. Warrant, specifying the warrant may authorize real 30. Time location tracking or acquisition of historical 31. Location data, providing the warrant may authorize the 32. Use of the mobile tracking device as specified. 33. Requiring the warrant to command the officer to 34. Complete any installation authorized by the warrant. 35. Within a certain time frame, providing requirements for 36. The return of the warrant to the judge and service of 37. A copy of the warrant on the person who was tracked or 38. Whose property was tracked, specifying how a warrant 39. Authorizing the acquisition of historical location 40. Data must be returned and served, authorizing a court 41. For good cause, to postpone the notice requirement for 42. A specified time period, requiring that the standards 43. Established by Florida courts for the installation 44. Use, or monitoring of mobile tracking devices and the 45. Acquisition of location data apply to the 46. Installation, use, or monitoring of any devices and 47. The acquisition of location data as authorized. 48. Deleting the definition of tracking device. 49. Authorizing any investigative or law enforcement. 50. Officer who is specially designated by certain persons. 51. And who makes specified determinations to engage in. 52. Real-time location tracking if a warrant is later. 53. Obtained as specified, providing requirements for. 54. Engaging in real-time location tracking, specifying. 55. When real-time location tracking must terminate. 56. Providing an effective date. 57. 58. Be it enacted by the legislature of the state of Florida. 59. 60. Section 1. Section 934.01, Florida Statutes, is amended to 61. Read. 62. 934.01 Legislative findings on the basis of its own. 63. Investigations and of published studies, the legislature makes. 64. The following findings. 65. 1. Wire communications are normally conducted through the 66. Use of facilities which form part of an intrastate network. The 67. Same facilities are used for interstate and intrastate. 68. Communications. 69. 2. In order to protect effectively the privacy of wire. 70. And oral and electronic communications, to protect the 71. Integrity of court and administrative proceedings, and to 72. Prevent the obstruction of intrastate commerce, it is necessary. 73. For the legislature to define the circumstances and conditions. 74. Under which the interception of wire, and oral, and electronic 75. Communications may be authorized and to prohibit any 76. Unauthorized interception of such communications and the use of 77. The contents thereof in evidence in courts and administrative 78. Proceedings. 79. 3. Organized criminals make extensive use of wire, and 80. Oral, and electronic communications in their criminal 81. Activities. The interception of such communications to obtain 82. Evidence of the commission of crimes or to prevent their 83. Commission is an indispensable aid to law enforcement and the 84. Administration of justice. 85. 4. To safeguard the privacy of innocent persons, the 86. Interception of wire, or oral, or electronic communications when 87. None of the parties to the communication has consented to the 88. Interception should be allowed only when authorized by a court. 89. Of competent jurisdiction and should remain under the control 90. And supervision of the authorizing court. Interception of wire 91. And oral, and electronic communications should further be 92. Limited to certain major types of offenses and specific 93. Categories of crime with assurance that the interception is 94. Justified and that the information obtained thereby will not be 95. Misused. 96. 5. To safeguard the privacy of innocent persons, the 97. Legislature recognizes that the subjective expectation of 98. Privacy in real-time cell site location data, real-time precise 99. Global positioning system location data, and historical precise 100. Global positioning system location data which society is now 101. Prepared to accept is objectively reasonable. As such, the law 102. Enforcement collection of the precise location of a person 103. Cellular phone, or portable electronic communication device 104. Without the consent of the person or owner of the cellular phone 105. Or portable electronic communication device should be allowed 106. Only when authorized by a warrant issued by a court of competent 107. Jurisdiction and should remain under the control and supervision 108. Of the authorizing court 109. 6. the legislature recognizes that the use of portable 110 electronic communication devices is growing at a rapidly 111 increasing rate. These devices can store, and encourage the 112 storing of, an almost limitless amount of personal and private 113 information. Often linked to the Internet, these devices are 114 commonly used to access personal and business information and 115 databases in computers and servers that can be located anywhere. 116 in the world. The user of a portable electronic communication 117 device has a reasonable and justifiable expectation of privacy. 118 in the information that these devices contain. 119, 7, the legislature recognizes that the use of household 120 electronic devices, including microphone-enabled household 121 devices, is growing at a rapidly increasing rate. These devices 122 often contain microphones that listen for and respond to 123 environmental cues. These household devices are generally 124 connected to and communicate through the Internet, resulting in 125 the storage of and accessibility to daily household information. 126 in a device itself or in a remote computing service. Persons 127 should not have to choose between using household technological 128 enhancements and conveniences or preserving the right to privacy. 129 in one's home. 130 Section 2. Subsection 2 of Section 934.02, Florida 131 statutes, is amended, and subsections 27 and 28 are added to 132 that section, to read 133 934.02 definitions as used in this chapter. 134, 2, oral communication means any oral communication. 135 uttered by a person exhibiting an expectation that such. 136 communication is not subject to interception under circumstances. 137 justifying such expectation, including the use of a microphone. 138 enabled household device, and does not mean any public oral. 139 communication uttered at a public meeting or any electronic. 140 communication. 141, 27, microphone-enabled household device means a device. 142 sensor, or other physical object within a residence. 143, a, capable of connecting to the Internet, directly or 144 indirectly, or to another connected device. 145, b, capable of creating, receiving, accessing, processing. 146 or storing electronic data or communications. 147, c, which communicates with, by any means, another entity. 148 or individual, and 149, d, which contains a microphone designed to listen for and 150 respond to environmental cues. 151, 28, portable electronic communication device means an 152 object capable of being easily transported or conveyed by a 153 person which is capable of creating, receiving, accessing. 154 processing, or storing electronic data or communications and 155 which communicates with, by any means, another device, entity. 156 or individual. 157 Section 3. Section 934.21, Florida Statutes, is amended to 158 read. 159 934.21 Unlawful access to stored communications. 160 Penalties. 161, 1, except as provided in subsection 3, whoever. 162, a, intentionally accesses without authorization a facility. 163 through which an electronic communication service is provided. 164 or 165, b, intentionally exceeds an authorization to access such. 166 Facility. 167. 168 and thereby obtains, alters, or prevents authorized access to a. 169 Wire or electronic communication while it is in electronic. 170 Storage in such system shall be punished as provided in 171 subsection 2. 172, 2. The punishment for an offense under subsection 1 is 173 as follows. 174, a, if the offense is committed for purposes of commercial. 175 Advantage, malicious destruction, or damage, or private. 176 Commercial gain, the person is. 177 1. In the case of a first offense under this subsection. 178 Commits guilty of a misdemeanor of the first degree, punishable. 179 as provided in S 775.082, S 775.083, or S 934.41. 182. In the case of any subsequent offense under this. 181 subsection, commits guilty of a felony of the third degree. 182 punishable as provided in S 775.082, S 775.083, S 775.084, or 183 S 934.41. 184, b, in any other case, the person commits is guilty of a 185 misdemeanor of the second degree, punishable as provided in S. 186 775.082 or S 775.083. 187, 3, subsection 1, does not apply with respect to conduct. 188 Authorized. 189, a, by the person or entity providing a wire, oral, or 190 electronic communications service, including through cellular. 191 phones, portable electronic communication devices, or 192 microphone-enabled household devices. 193, b, by a user of a wire, oral, or electronic communications. 194 service, including through cellular phones, portable electronic. 195 communication devices, or microphone-enabled household devices. 196 with respect to a communication of or intended for that user, or 197, c, in S 934.09 or S 934.23, or S 934.24. 198, d, in Chapter 933, or 199, e, for accessing for a legitimate business purpose. 200 Information that is not personally identifiable or that has been 201 collected in a way that prevents identification of the user of 202 the device. 203 Section 4. Section 934.42, Florida Statutes, is amended to 204 Read. 205 934.42 Mobile Tracking Device and Location Tracking. 206 Authorization. 207, 1, as used in this section, the term 208, a mobile tracking device means an electronic or 209 mechanical device that permits the tracking of the movement of a 210 person or an object. 211, b real-time location tracking means 212.1 installation and use of a mobile tracking device on the 213 object to be tracked. 214.2 acquisition of real-time cell site location data, or 215.3 acquisition of real-time precise global positioning. 216 system location data. 217, c historical location data means historical precise. 218 global positioning system location data in the possession of a 219 provider. 220, 2, 1, an investigative or law enforcement officer may make. 221 application to a judge of competent jurisdiction for a warrant. 222 an order authorizing or approving real-time location tracking, or 223 the acquisition of historical location data in the possession of. 224 the provider the installation and use of a mobile tracking. 225 device. 226, 3, 2, an application under subsection 2, 1, of this 227 section must include 228, a statement of the identity of the applicant and the 229 identity of the law enforcement agency conducting the 230 investigation. 231, b, a statement setting forth a reasonable period of time. 232 that the mobile tracking device may be used or the location data. 233 may be obtained in real time, not to exceed 45 days from the 234 date the warrant is issued. The court may, for good cause, grant 235 one or more extensions for a reasonable period of time, not to 236 exceed 45 days each. When seeking historical location data, the 237 applicant must specify a date range for the data sought. 238 certification by the applicant that the information likely to be 239 obtained is relevant to an ongoing criminal investigation being 240 conducted by the investigating agency. 241, c, a statement of the offense to which the information 242 likely to be obtained relates. 243, d, a statement as to whether it may be necessary to use 244 and monitor the mobile tracking device outside the jurisdiction 245 of the court from which authorization is being sought. 246, 4, 3, upon application made as provided under subsection 247, 3, 2, the court, if it finds probable cause that the 248 certification and finds that the statements required by 249 subsection 3, 2, have been made in the application, must grant 250 a warrant shall enter an ex parte order authorizing real-time 251 location tracking the installation and use of a mobile tracking 252 device or the acquisition of historical location data. Such 253 warrant order may authorize the use of the mobile tracking. 254 device within the jurisdiction of the court and outside that. 255 jurisdiction but within the state of Florida if the mobile 256 tracking device is installed within the jurisdiction of the 257 court. The warrant must command the officer to complete any 258 installation authorized by the warrant within a specified period. 259 of time not to exceed 10 calendar days. 260, 5, 4, a court may not require greater specificity or 261 additional information beyond that which is required by law, and 262 the section as a requisite for issuing a warrant and order. 263, 6, within 10 days after the time period specified in 264 paragraph 3, b, has ended, the officer executing a warrant must 265 return the warrant to the issuing judge. When the warrant is 266 authorizing the acquisition of historical location data, the 267 officer executing the warrant must return the warrant to the 268 issuing judge within 10 days after receipt of the records. The 269 officer may do so by reliable electronic means. 277, within 10 days after the time period specified in 271 paragraph 3, b, has ended, the officer executing a warrant must 272 serve a copy of the warrant on the person who, or whose 273 property, was tracked. When the warrant is authorizing the 274 acquisition of historical location data, the officer executing 275 the warrant must serve a copy of the warrant on the person whose 276 data was obtained within 10 days after receipt of the records. 277 service may be accomplished by delivering a copy to the person 278 who, or whose property, was tracked or data obtained, or by 279 leaving a copy at the person's residence or usual place of abode. 280 with an individual of suitable age and discretion who resides at 281 that location and by mailing a copy to the person's last known 282 address. Upon a showing of good cause to a court of competent 283 jurisdiction, the court may grant one or more postponements of 284 this notice for a period of 90 days each. 285, 8, 5, the standards established by Florida courts and the 286 United States Supreme Court for the installation, use, or and 287 monitoring of mobile tracking devices and the acquisition of 288 location data shall apply to the installation, use, or 289 monitoring and use of any device and the acquisition of location 290 data as authorized by this section. 291, 6, as used in this section, a tracking device means an 292 electronic or mechanical device which permits the tracking of 293 the movement of a person or object. 294, 9, a, notwithstanding any other provision of this chapter. 295 any investigative or law enforcement officer specially. 296 designated by the Governor, the Attorney General, the statewide. 297 prosecutor, or a state attorney acting pursuant to this chapter. 298 who reasonably determines that. 299 1. An emergency exists which 300A involves immediate danger of death or serious physical. 301 injury to any person or the danger of escape of a prisoner, and 302B requires real-time location tracking before a warrant. 303 authorizing such tracking can, with due diligence, be obtained. 304 and 305 2. There are grounds upon which a warrant could be issued. 306 under this chapter to authorize such tracking. 307. 308 may engage in real-time location tracking if, within 48 hours. 309 after the tracking has occurred or begins to occur, a warrant. 310 approving the tracking is issued in accordance with this. 311 section. 312, b, in the absence of an authorizing warrant, such tracking. 313 must immediately terminate when the information sought is 314 obtained, when the application for the warrant is denied, or 315 when 48 hours have lapsed since the tracking began, whichever is 316 earlier. 317 Section 5. This Act shall take effect July 1, 2019.
Hey Sheriff County, this is Sheriff County COPWATCH. I am using any video here with under fair use if you have criticism, reporting, teaching, etc. And please donate. I do not make money from YouTube, and there are different ways to donate in the video links. Thanks.